Good afternoon. My name is Rodrigo Camarena, and I am the director of the Immigration Advocates Network, a program of ProBonoNet. The Immigration Advocates Network was founded in 2007 by ProBonoNet in collaboration with leading immigrant rights organizations concerned with increasing access to justice for immigrants. Our mission is to advance immigrant justice through collaboration and technology. We partner with leading immigrant advocacy groups to find solutions and develop industrial strength immigrant legal tech that is secure, easy to use, and designed for scale. This is a picture of one of our current partners, Make the Road New York, who we're designing a tool to combat wage theft with. Whether it's by supporting legal permanent residents with naturalization, helping undocumented folks know their rights, or facilitating access to legal assistance nationwide, the Immigration Advocates Network works to take on big problems and bring technology and resources where they're needed the most. Since 2007, we've assisted more than 500,000 immigrants and built a network of over 10,000 advocates around the country. Central to ProBonoNet's mission has been promoting innovations that deliver new capacity to communities we serve and engage new allies in the Access to Justice mission. Just as 20 years ago, the changing role of technology and its impact on the legal industry led Mark and Michael to explore how these solutions could promote deeper engagement between legal aid organizations and the private bar. Our next panel will explore how new innovations in litigation finance might be harnessed to support strategic enforcement and protect public rights. I don't, in this crowd full of advocates and attorneys, I don't have to tell you that the daily threats to our immigrant friends and neighbors are severe. Yet they're being met with protests, direct actions, new initiatives, tools, and campaigns, as well as legal action by groups like the ACLU, the Immigration Council, and the National Immigration Law Center. Litigation that's made possible by the philanthropic sector and support from Big Law. From the Muslim ban to family separation and the plan to cut federal funding to sanctuary cities, litigation has emerged as a critical need in the defense of civil liberties and immigrant communities. The next panel will explore whether these new models might create new opportunities to support this critical and important work. We can not have a better facilitator for today's discussion in Judge Shira Schindlin, appointed in 1994 to the Southern District of New York by President Bill Clinton. Judge Schindlin served on the Federal District Court for more than 22 years. Judge presided over a number of high-profile cases, including Floyd versus New York, where Judge Schindlin ordered the NYPD to cease its practice of conducting stop and frisks that were not based on reasonable suspicion of criminal conduct. After a distinguished career in public service, Judge Schindlin joined the litigation practice at Strzok, where she practices as a neutral. Please join me in welcoming our moderator, Judge Shira Schindlin.
Well, thank you so much, and I'm delighted to be here. This is a very special audience, I think, and so I'm pleased to be speaking to you today. Let me give you just a brief preview of our panel and introduce our speakers, and then we're going to get right to it. Legal finance companies are driving innovation in private law practice, but today we also focus on a different question. How can new capital increase access to justice for the poor and other vulnerable populations? We intend to address this in 3 segments, short segments. First, we will present an overview of the legal finance market and why companies access this funding. Second, we will describe the many ways in which public impact litigation is funded today. Third, we will look to the future and discuss what different models have or might emerge from various sources of funders, focusing in particular on litigation funders. With luck, at the end of all this, we're going to leave 5 to 10 minutes. Hopefully, somebody here is going to have a question or two. Now, to accomplish all of this in a mere 45 minutes, we've assembled what I think is the best possible panel on this cutting-edge subject. We begin our first segment with Ralph Sutton, who has been a litigation funder for over 13 years and now leads a new venture, Validity Finance, his very own creation. Following an 18-year career as a trial attorney, he co-founded Credit Suisse's litigation group in 2006, one of the first dispute funding entities in the U.S. He then led Bentham's U.S. operation for 6 years as its chief investment officer. Our next segment will be led by Heidi Doro and Ben Elga. Heidi has over 20 years of philanthropy and advocacy experience in a range of human rights issues, including LGBT rights, immigration, child welfare, and juvenile justice. At Borealis Philanthropy, Heidi is the Director of Immigration Initiatives, overseeing the Immigration Litigation Fund, which provides grant support to impact litigators challenging overly broad and inhumane immigration enforcement policies and practices. And as you know, there are many of those to challenge. Ben Elga is the Executive Director of Justice Catalyst and Justice Catalyst Law, a nonprofit law firm. Justice Catalyst serves as a philanthropic advisor, organizes conferences, and administers a fellowship program for innovative legal projects. Just Catalyst Law develops impact litigation about economic and social justice with a focus on interdisciplinary legal work and access to justice, including cases at the intersection of the criminal justice system and competition law. Now, our third segment is going to be a free-for-all in which all the panelists here will share their ideas. And with that, I turn it over to Ralph Sutton.
So I have 5 minutes.
Thank you.
I have 5 minutes to give you about an hour's worth of overview. So please forgive me and let me know if I'm speaking too fast. And I guess since I'm the first of the panelists, I'll say it's impossible to follow what we've heard today with any kind of sense of anything except humbleness and humility. And I was fighting off the tears, I really was. And that's from a hard-bitten funder, as you'll hear. But okay, so let's start with a simple definition of litigation finance, what it is, what it isn't, and so on. What it is, the simplest way to say it is David versus Goliath and law firm portfolios that permit David versus Goliath funding. Now, for a more technical definition, if you'll follow me here, it's non-recourse investment of capital to a company or a law firm to assist with commercial litigation, fees and costs in exchange for a pre-negotiated return from the proceeds, typically 20 to 25%. And of course, non-recourse means if we lose the case, we lose any possibility of a return. So that's clear. We're usually on the plaintiff's side, almost always, and we're doing single cases and portfolios of cases with law firms. And so commercial litigation cases, as you might guess, breach of contract, fraud, IP, international arbitration, antitrust, and insurance disputes. Typical. Anything you could think of, but not personal injury, mass torts, malpractice, and class actions. Those are often considered consumer funding, and there's a lot more taxonomy we could go into that is not going to help us meet 5 minutes. So I was asked to mention very early what some of the benefits seem to be for clients and law firms. Well, I think the first thing that we have to do as funders is create value for clients, or we don't deserve to exist. And value for clients is the very best law firms on a contingency. So if you have a meritorious dispute and you're a small company or an inventor and you have to fight Google or any of the other wonderful tech companies or other companies in this country that may have taken something from you or breached a contract, you need a great firm to do it. And that great firm will do it on a full contingency. How will they do that? I'll explain it to you in a slide in a second. Next, for law firms, the way we operate is 50-50 on the fees. And so the law firms are investing half the fee budget to get a 3x to 5x return, which is amazing in this world, but also highly risky. Always, as you'll hear in a second, I'll give you some guiding principles, some Polestar principles. The law firm will do as well as the funder or better than the funder, which is incredible, but I'll show you how. And then we think this entire way of sharing risk better aligns the incentives of all the parties than the billable hour. right? That's an easy target. Everybody hates the billable hour. Okay, so let me grab the clicker to show you very quickly, the first of just 2 slides. And on the top, you see a law firm, and on the bottom, you see a funder like Validity. And what you see on the left is that we are each contributing to the client's case in the middle 50% of the fees, and the client and the funder will share the costs. And so this is a very schematized view of it, but the law firm will get 20% contingency, and the funder will get 20 or 25% recovery, and the client should get 60%. And all these are important things to talk about, and there's lots to say. But the way we design these deals, the 20% recovery for the firm and for the funder should yield us both 3x to 5x. So we're getting exactly the same as the law firm taking the risk, although we're putting up capital and law firms are putting up hours. And here we're contracting with the client. Here, this is a portfolio where we're contracting with the law firm and we're taking a smaller return in order to give the law firm, again, 50% of the fees, and they can therefore offer more clients contingency. And I'm going to stop with the demonstration on that because it could go on for a long time.
Also, you're already at 5 minutes.
Am I?
It flies.
Okay, I'll end with one concept, and I'll throw my other comments in later.
Yeah.
Generally speaking, the client will pay no more than 5% of the total cost of litigation, and the cost of litigation, as you know, is outrageous, and sometimes is 3 million, 5 million, 10 million, and 20. Let me pause.
Okay, thank you, Ralph. I think we're now going to do segment 2, which is where are we now, the present. We're going to start, before we go to the future, we have to understand the present. So Heidi, let's start with you and then Ben.
Sure. I have some handouts
Oh.
that people, take home. So I'm Heidi Doro. I work at a place called Borealis Philanthropy, and Borealis Philanthropy is a funder intermediary. For those of you not steeped in the funding world, what that means is that we're a public charity. We're a grant seeker and a grant maker. We don't sit on top of an endowment of our own money. We have to partner with foundations to then develop new grant making strategies and mechanisms to do grant making for those foundations. And we provide them for something they can't do by themselves. It might be speed, it might be content expertise. Most often, it's a way to leverage dollars. So foundations come to us, and we primarily form funder collaboratives. A bunch of foundations pool their money at an intermediary, and then we devise some sort of grant-making strategy on their behalf. So I'm actually not representing innovation, I don't think, so much as I'm a classic kind of funder lady, right? Working with foundations. But I think the thing that hopefully is interesting and useful to the conversation is that we run something called the Immigration Litigation Fund, and that was created in 2017 to support impact litigation challenging immigration enforcement policies and practices. That was on purpose. That started in 2017 to respond to a wave of new policies and practices meant to increasingly either keep people out of the country through barriers to access or get them out when they were here. Thus far, we've supported about, this information is a little old, but we've supported about 120 grantees with about $7 million of funding and supported roughly about 70 pieces of litigation. And all of that litigation is challenging enforcement policies and practice. That's everything from challenging the Muslim ban to challenging termination of DACA to more in the weeds kind of work. For example, challenging new policies as it relates to access to special immigrant juvenile status for young immigrants. So I think that the main takeaway here in the few moments that I think is important is that letting litigators know that there's resources available gets them going. I mean, I think the current climate is responsible for most of the litigation, but if people know there are resources out there to support their ideas, to support their aggressive behavior toward bad policy, people, like, if you build it, they come, right? So when we started doing our grant making, I had plenty of money and I kind of just waited for people to come to me with the litigation ideas. And now in our last round of grant making, I could only fund half of the proposals I received. I got 31 proposals for 31 pieces of litigation, and sometimes more than 31, and I could only fund half of them.
Were the other half, were they meriting funding? If you
Absolutely. If I had the money, I would have funded all of them.
Okay.
Maybe 30.
30 of the 31. Pretty good.
Right? So, and most of the litigation that we're funding is litigation in federal court, mostly against the government, not always, sometimes against corporations or states. But we have proof of concept, right? There's things to challenge, there's things to fight, and if you have more money, you can fund more litigation. I think that's incredibly important in this moment. And my last point would be, this isn't just because litigators are clever and they want to explore interesting ideas. Litigation in this moment on immigration enforcement keeps families together, keeps people out of detention, prevents people from getting deported, or gets families reunited who have been kept apart because of exclusion policies. Litigation saves lives.
Okay. Thanks, Heidi. Ben?
Yeah, I kind of am a generalist. I move across a lot of different fields of litigation, and I guess I'm up here in part because one of my jobs is to think about how we can be more open-minded about how we think about what public interest litigation is. And so I think Ralph's comments touched on this, but a good deal of what I think the public interest litigation that is happening right now is being financed essentially on a contingency basis by plaintiffs' firms. And I think that we are tend to be somewhat rigid in our thinking about what counts as a matter that merits pro bono attention and what counts as a matter that merits contingency work. And I think there's a lot that gets missed in between the two. I also think that leads a lot of the people in the current philanthropic ecosystem to not think about damages as a potential tool for change. Damages are incredibly motivating, particularly when we're talking about private actors and somewhat the government, although there are some political problems with potentially getting a return on such things. And I think working with nonprofits to think about how damages can be part of their strategy is a really important step to making sure we don't miss very important things that are happening but don't fit neatly into one of those two categories.
Ben, before we leave the present, I should say Ben and Heidi, Ralph, all of us, are there a couple other models that are presently being used, such as partnering with big law firms? I think there are a number, probably big firm pro bono coordinators here in this audience today, and I know you consider which cases to work with organizations on, and when you do a great job. You invest the time and money of your firms to do it. So that's one other funding model in the current environment, right? And another one, I would think, there's some cases, of course, against the government do have fee shifting. And so the fee shifting, in some cases, is another current model. And Ralph, just for a moment to bring you into this, is there some current level of funding from litigation funders, either as sort of a philanthropic gesture or as a return on that investment, even in the pro bono space, currently, before we have that great futuristic conversation?
So at Bentham, when I was there, Bentham is a publicly traded Australian company. We were approached by Dean Erwin Chemerinsky to help him at UC Irvine Law School launch an Institute for Civil Justice. And we came up with a six-figure number over 3 years. And that was a pure philanthropic idea because we thought it would have incredible leverage to touch a lot of people and also provide a counterweight to some more conservative think tanks. I don't see a lot of examples of that, though.
Okay.
That was pretty unusual. Have you seen any others in your travels? And
I don't think I know exactly how the cases in front of me were funded. The less you know, sometimes the better. But so I don't know who put up the money. Okay, I think we would like to get that sort of futuristic moment here and see what some other ideas are that might take the funding of pro bono efforts to a new level. So this time, let me start with Ben and then just go down the line. Ben?
So I can report happily that some philanthropic efforts have taken a somewhat financing model in a very interesting way. The Impact Fund on the West Coast gives recoverable grants, and where their cases are successful, they will often take the amount they grant out back for just fees. For just expenses. And the Time's Up Litigation Fund has been offering financing for cases about sexual harassment, which they don't take back the full amount, but they'll take back a partial return on some of the successful cases. And I think that's a really interesting and important way to attract lawyers to work in areas that they might not have before, defray costs. In terms of what I think the future could hold, I think there's a tremendous amount of potential for people to work to enhance primarily enforcement where it's failing. So perhaps not as much for new rights, which introduce a tremendous amount of risk into an already risky kind of investment product. But I think there are a lot of cases where the rights are on the books and no one's out making them be followed. I also want to highlight that I think it's incredibly important to, in order to make that a possible vision, to break down some of the barriers to lawyer-directed financing. So Ralph pointed out that class actions are pretty much excluded from litigation finance as things stand, and I think a lot of the major problems that we face really need class treatment in order to achieve the kind of ends we want, or achieve them in an efficient way that doesn't require 10 years of litigation. And I think that is a major barrier to working on a lot of these issues.
Okay. Ralph, I think you can now pick up some of the time that I didn't give you before,
that's right.
because in explaining why you might be willing to invest in pro bono cases, you can probably complete the model that you were starting to talk about what litigation funders do and why they do it.
Sure. So we do it, well, I'll start with that. We do it for profit, and there's no way to sugarcoat that. But we also believe that what we're doing has a really strong element of leveling the playing field and creating, we don't use access to justice at validity. We use access to the courts because it is simply it's a cleaner way to describe what we're doing. I can, I think, safely say that we could recruit from the top firms, and we just recruited and brought on a Supreme Court law clerk, former Supreme Court law clerk, because what we're doing is changing the landscape of what's possible for uses of litigation, for damages. Litigation saves lives. I love all those concepts. What is the challenge for us, Judge, is that our investors are looking for a certain kind of return with a model. And what we have to do is create new buckets of possible investment, like low returns. So some allocation to not 3x to 5x, but maybe it's 1.5x to 2x, which could be acceptable depending on the time frame and so on, and really have a focus on how important our role could be in giving back to the community. That's what I believe. I think we have to push for that. We do at Validity plan to make innocence type of loans for exonerated prisoners at no return. So that'll just be money out, money back, with a tiny cost of capital, which we have to charge, or we won't be able to do it. But that effectively expands it as well. And I think there's a lot more to say, and I almost feel like we need a separate conference rather than a 45-minute on this. But this is such a wonderful opportunity to get to talk about.
Let me ask you one question before I move on to Heidi. No, there's a difference between the fees that a firm would charge and is willing to absorb when they do pro bono work, but the costs are different than the fees. You have to lay out money to hire experts, to fund the court reporter for depositions, the cost. Do you distinguish sometimes between costs and fees? And in this pro bono area, would you consider the thought of just cost to help the pro bono entity be able to move the case forward?
Absolutely. I think that I can go on and on about this subject too.
Well, do it shorter.
Well, I'll do it shorter. Of course I will. What I want to propose is evergreen funds, where funders help set up an amount of money that will get a legal services organization through a certain period of time on costs in important cases, and will probably not recover that. I think we have to kind of get to that. But the bigger the number, the harder it is not to recover. And then attorney's fees and other statutory vehicles will return the money into the cost fund, and then costs will forever be covered. That's what I want to do.
And one more for you. Did you not have an example involving FEMA that you were going to talk about a little bit?
I did, but I was trimming my sails, Judge. So a law firm that had gone all the way to the Supreme Court in Katrina approached us and wanted to help FEMA Sandy policyholders who suffered under Sandy because FEMA systematically underpaid their cost estimates in all the states, and it was really a tragedy. 140,000 claims were eligible to be reopened. Only 14,000 were reopened, and the firm that we supported with this program was able to give and it was 1,200 policyholders, was able to give every single homeowner a new adjustment so that they could bring that fresh adjustment to FEMA, and FEMA was basically forced to pay 4 times more to our claimants than any other represented claimants, much less unrepresented claimants who got even less. So our average was 28 versus 7, and that was a low return rather than a full return situation.
Got it. Okay, Heidi, if you could predict or have the future be what you want it to be, what would you want it to be?
Well, I think in the immediate future, I think what is the role of accountability for harms currently happening. And I think that this is part of a historical accountability, financial accountability. How do we compensate for harm and damages, and long-term trauma? And how can that accountability then be used, to change the future? And what choices are made? What policies are implemented or not implemented?
But so that sounds like the generality of reforming the tort system, and for a moment, that's too big a topic. So I was thinking more of the
Believe me, I am not.
You sound like a reformer, but let me focus you again on the
I have
sort
a
of the,
BA
yeah. No.
from a hippie school.
Let me just focus you for a minute on the underprivileged, the poor, the minorities, those who lack the funding. I want to focus on those groups more than a general discussion of responsibility, accountability, and damages and tort. But in general, how do we focus on those who really, as Ralph put it, cannot afford access to courts?
Well, but that is exactly what I'm talking about.
Okay.
That's
okay.
exactly what I'm talking about. And I'm not necessarily talking about, I'm talking about using accountability mechanisms. Obviously, we want to help the individual who has been harmed or individuals who have been harmed. But I think that how do we use accountability mechanisms to change the course of history and future choices? If there's accountability for the separation of children, right, in the historical record, if a family gets compensated for that, or the process of seeking that compensation and all the records and the documents that are FOIA'd because of that, to me that changes our future, or it has the potential to change our future.
Okay, I think I understand. I guess to me, when you talked about accountability, could also be responsibility for the crash of an airplane. Is the company liable to all those people who were hurt? So I was trying to focus on the groups that you're now discussing, which is good. So let me go back to Ben for a minute and talk about class actions a little more. You had we had some really good prep sessions. Let me tell everybody, we had such fun mapping out what we were going to cover today. And one of the topics I think that you were going to speak about, Ben, was developing models to support class cases, and you wrote probably lawyer-directed financing. Could you expand on that a little?
Sure. So I think one of the barriers that faces financing class actions, well, there's a lot of them, but one of them is that lawyer-directed financing is not the primary model that commercial litigation finance has taken, and the class representative is not in a position to basically bargain on behalf of the class about how the recovery is going to be treated. So the lawyers really have that responsibility, and there needs to be a lot of thought about how that's going to play out if financing became a big part of these class cases, in part because the settlements get scrutinized by judges. And so judges need to be okay with the financing structures that we want to put in place. And there needs to be some comfort about that on the front end for the lawyers and the litigants in order to be able to enter one of these.
You know, that's interesting because I think traditionally judges really didn't want to get into the facts of who's financing what. That really wasn't their business. If a law firm took out a loan from the bank, the judge didn't know that. If a plaintiff got financing, nobody wanted to know that. Now there's suddenly a push for more transparency, and particularly in class actions and MDLs, we see the court wanting to have a little more information about that.
I mean, I think it's a potentially relevant factor to adequacy, and when you have that in play and the sides get into discovery, there's a lot to talk about. But I also think that one of the things Ralph touched on is in the wake of the difficulties in getting classes certified these days, models that find other ways to aggregate claims are going to be increasingly important. And so working to aggregate claims through innovation, like reaching out to individual people is
And I think that you also were going to talk a little bit about employment cases and how they've traditionally been handled by the pro bono bar and how you think they might be able to be handled going forward.
Well, I raised the employment cases because I think it's a place where there is a somewhat functional use of capital to help work with nonprofits, particularly. So there are nonprofits that kind of have zones of organizing for their work, and outside of those zones, when they see cases, they'll refer them to private attorneys, and they'll co-counsel on those cases, and that work can help sustain their core missions. And because they're on the ground working with people, they know a lot of the key facts that are necessary to build these cases that otherwise lawyers would never find out about.
Okay, I think we have reached a point, although if there are no questions, we'll find a way to keep talking until 5:15, but we would be happy to respond to questions that you might have for any of us. I can't see everybody past the podium, but one or more of us would probably want to engage with you if you have any questions. And oh, good, and there's a lot of you. So yes, your first question.
Hi, my name's Dorothy Thomas.
And Ms. Thomas, you work where, or did, or
well,
do, or?
You know, it's a funny question. Okay. I'll just say that I'm the wife of the co-founder of ProBonoNet.
Great, okay.
I have other roles, but I'll just cop to that right here.
Sounds good to me, okay.
I'm really interested in the cross section between the four of you on the panel, because you are all coming from slightly different angles into this issue, and you're also active in different sectors. And the kind of question I have, like when I listen to somebody like Heidi, who has more cases coming to her that are litigatable than she can resource. Right. And then you have an increasing amount of potentially new financing models emerging, maybe not so much in the pro bono area. I start to think, isn't there a way where, the shortage of money, let's say for pro bono in the kind of things she runs, reflects a lack of charitable contribution to that kind of work. It's just a simple fact that litigation isn't the front end of where a lot of the charitable money goes. And maybe on the finance side, the pro bono thing isn't where a lot of the litigation money goes. So I just wonder, is there a marriage there, or is there too many potential conflicts of interest? Where is there a possibility to essentially lift everybody's boats? Or am I asking a question that is
it's a great question.
unanswerable?
Well, that's a different issue, but it's a great question. It's a great question, and I think I'll just take a start at it. So besides the work I did as a judge, besides the work I do now as a neutral, I do sit on several nonprofit boards at a pretty serious level, and at least two of them do a lot of litigating. One is the Bronx Defenders, which many of you know about. One is the Lawyers Committee for Civil Rights, which I hope all of you know about. And those two entities really, really litigate. Now, where do they get their funding? They get foundation grants. They're very good at fundraising. They get a lot of foundation money. The Bronx Defenders gets money from the city of New York. So governments, by the way, governments have also funded immigration defense work. Unbelievable how well some cities have funded immigration defense. So they get money from foundations, they get money from public sources. They all partner with law firms, and the law firm partners who are here, including the fellow in front of you, so generous. These firms have really stepped up, especially in the years since January 2017. They've really stepped up in the immigration space and many other spaces, and their partnering has been a wonderful source of funding. The reason for this panel, I think, was to say, those have been great areas of funding, and yet it's not enough, and yet it's not enough. And where do we take the next step? Which is why we have a litigation funder on the panel. But we don't want to skip over. Let's go down the line and try to answer your question. So Heidi, anything you want to add? I'm sure you do. Yeah, but okay. Whoops. I always say the wrong thing.
I mean, I don't. I think that, I mean, the groups that you mentioned, they're my grantees, right? So I am the person actually, surprisingly, who is the traditionalist on the panel, or coming from the traditional role of, I work with foundations to get their money to give it to the people who are trying to do the good things.
Right.
So I mean, I'm looking for ways.
Good.
I'm looking for the answers too, for how do we increase those resources. I think the one thing that is more challenging in traditional philanthropy is that a lot of foundations actually don't want to fund litigation. So, or that's not their main focus, or they think that's not for me, that some other funder is going to take care of that. So.
All right, Ralph?
So I think the perspective that I have is that we're still in the second or third inning of the funding game, baseball game that is, and it is difficult for startups to imagine doing anything but the thing that they have to do right in front of them to keep their companies going. So we're at the very earliest moment. So could there be a marriage? There could definitely be a lot of dating and going steady maybe and more. But I think that's the sort of structural problem in time, right? And I think law firms who are big law often, to say, almost always have the bulk of their practice in defense, are not sure yet how funding is going to help them, and we're working on that. Because eventually, Goliath versus Goliath will do a risk transfer. But since the players that are participating have not yet reached adolescence, much yet any kind of maturity, we have that problem. We also don't have an association. If we had an association, which a lot of people are talking about now, creating after one of the largest funders had a short seller attack, which really diminished their stock value, the question became, well, how do the funders adopt standards? Who's credible? Who's not credible in that world? In an association, the very inventive and innovative minds that have joined this industry can begin to think about how to give back, and that hasn't happened yet. So we're still in those early innings, and I think that's a large part of the explanation from where I sit.
You know, I would add, Ralph, that we had a study that showed the kinds of settlements we've gotten in some of these impact cases.
Yeah, that would help.
There's money to be made. I know that one of the big cases that the Lawyers Committee worked on for about a decade was a housing discrimination case in Nassau. And in the end, there was a tremendous financial recovery. It was eventually donated back to the Lawyers Committee, which was very generous of the law firm. But in fact, a lot of money was recovered, and that happens. Not saying in every impact case by any means, but we talked about damages a moment back. You made a very good point about damages and accountability. There can be a financial incentive, as you pointed out, just a lower rate of return. When the funders see that maybe there's money to be made, they may step up even more than the sort of good deed people like Ralph, who did it as a gift, as a philanthropic gift. But they may see that this is actually a place that they want to invest in, although at a lower rate. Ben, your thoughts on that very interesting question we got?
I have two quick thoughts. The first is, I think this is starting to change, but a lot of traditional philanthropists are not so interested in nonprofits being able to sustain themselves on litigation work. Not all, certainly some are open-minded about it. And I think that an interest in understanding that aspect of the legal system and how it can really be used to force multiply your work is a really valuable awakening that is starting. I think that's, and could lead to a lot more great cases being brought. The other thing I would just note is that one of the really exciting things about litigation finance is that if you want a business loan to start a law firm, that's not really something that you can get right now. And so it's a little hard to tell how much innovation could happen among lawyers, because you can't really have innovation without financing. And so for the young associate who has a really good idea and wants to go out and start a firm, there's no way to do that unless you have the personal assets to back it up.
What about traditional bank financing?
Traditional banks will often not do it without a personal guarantee, and as far as I know.
All right, I see a question way in the back. Yes.
One thing I think about is the public, with respect to big law, is the public perception if impact litigation, which up to now we did pro bono and donated any fee award that exceeded our expenses, is now something that we're looking at as a for-profit venture. I think that could be perceived very poorly, and there could be a lot of pushback about it.
I think one of the reasons that is likely the case has to do with the fact that traditional impact litigation involves suing the government, and I do think there's something potentially problematic about trying to generate a return off that. I think if you thought about cases that had private actors on the other side who were taking advantage of people, I think that would be less of a concern. Right?
Can I jump in?
Ralph,
Yeah.
please.
It's a great question. And I'm so excited to have this discussion further, maybe with you another time. As you know, Judge Gleason works with us from time to time on our investment committee. And I think that the question's flaw, if I may, is it assumes a profit. The firm doesn't have to take a profit, right? And the funding can help the firm do more of them, perhaps by covering the costs, or perhaps by even covering some of the fees. So if there's a way to turn back any profit to an organization that's involved, that solves the problem of perception, I think.
Right. So I have to ask you folks, it's 5:15. Do we have to stop, or can we take your question? We could take your question because you're in charge. So your question is, and please identify yourself, and the mic will be coming your way, I'm sure. There it is. Okay. Tell us who you are.
Thank you. I'm Ed Walters. I'm the CEO of Fastcase, and I serve on ProBonoNet's board. Utah recently has liberalized the laws around ownership of law firms. California is considering it. I think many other states are as well. Would liberalized ownership of law firms change the space at all, and if so, how?
Are you saying that they wouldn't have to be lawyers, that it could be investors that own a law firm, non-lawyers? Is that one
Anybody.
Anybody, so not necessarily a lawyer. Reactions?
Well, it's a game changer for sure. And what would be fascinating is if law firms or legal services groups could be carved out more rapidly than the cultural walls that exist for general non-lawyer ownership. So if legal services could have investors, for instance, versus every law firm as a first step, we'd see a lot of innovation around that, I think. I really want to hear from Scott, who's thought about all this so deeply and is on the board too. But yeah, I think it's a great opportunity.
Does anybody on the panel think otherwise, out of curiosity? Any reaction to non-lawyers owning law firms?
I think it's exciting.
I think it's exciting. All right, all right.
Well, I think we have to say, Judge, I mean, part of this idea that non-lawyers can't is crippling law firms. It's crippling law firms because there can't be equity currently in the law firms. And so partners who retire can't take some of that equity as retirement, so they have to do many strategies to keep the money that's in the firm for themselves as they're older, which isn't healthy for younger lawyers, isn't healthy for younger partners, isn't healthy for retention.
No,
so there's
they're
a whole...
at least lawyers, though. The retiring partners are lawyers. I had some concern about non-lawyers being in ownership because they might be directing decisions on litigation decisions, and we don't want, I think, non-lawyers practicing law even in that sense. That's always been one of the fears about litigation finance, are the investors telling the lawyers when to settle or how much to settle for or when to bring a motion or not bring a motion, et cetera. So that's my only concern.
So that can be dealt with, though.
I'm sure it can. We probably don't have time to
Yeah.
debate it thoroughly, but I thought I would raise the opposite point of view briefly. So give me guidance. Do we take another question or do we stop?
More questions?
Are there more questions? Anyone else in this big room have a question for us? Well, if not, we are grateful for the questions we did get. They all stimulated, as you saw, further discussion. And thank you again for having us.
Thank you, Judge.
Pleasure to meet you.